Hello, everyone. In this podcast, we will be discussing sensitive topics such as sexual assault. It's important to take care of yourself while listening. Some suggestions are listening while you're in a healthy headspace or knowing who you can reach out to if you become upset. Our 24/7 helpline for crisis calls based out of Central Florida is 407-500-HEAL. By contacting the national hotline at 1-800-656-4673, you can get support and learn about your local resources. There's always someone ready to help.
The Victim Service Center podcast. Here we sit down with professionals that serve survivors and victims of trauma, or those who have experienced violence, and have conversations about social issues. This week, we are talking about Title IX. My name is Emilie Mitchell, and I am the Education Coordinator at the Victim Service Center. With me today, I have Matt Ricke. His pronouns are he, him, his. Dr. Ricke is the Assistant Director of the Office of Institutional Equity and Title IX Coordinator for the University of Central Florida, where he has served since 2018. Matt has had the privilege of presenting locally and nationally on Title IX and gender-based misconduct, among other topics. Thank you so much for being here, Dr. Ricke.
Thank you, Emilie, for the opportunity.
And I also have Sarah Laake. Her pronouns are she, her, hers. Sarah is the director of the Office of Title IX at Rollins College, a role she has held since December 2018. She enjoys being a mom, cooking, watching sports, especially Gamecock football, Terrapin basketball, and Capitals hockey, and going to Disney. Thank you, Sarah, for also being here today.
Thanks so much, Emilie. And prior to joining Rollins, I had the privilege of working with Matt at UCF. So we have a long history together.
Yes, we do.
Awesome. I'm really excited to have this conversation with both of you. As a brief introduction, Title IX is a law that protects people from discrimination based on sex and education programs. Earlier in May, U.S. Secretary of Education Betsy DeVos released a pretty lengthy document addressing changes to Title IX that are set to go into effect August 14th. What we are looking to explore is what is a more detailed definition of Title IX than the one I gave? What are the changes coming in August? And how do college Title IX offices help protect those being discriminated against? So with that in mind, I wanted to just start off with what exactly is Title IX and how does Rollins and UCF's Title IX office support students and faculty? I can throw it to either of you first off. So whoever wants to jump in first.
I'm happy to jump in. So Title IX is a federal civil rights law that went into effect in 1972. It is a prohibition of sex-based discrimination in any educational program that receives federal assistance. That covers the majority of our pre-K through 12 institutions in the United States, as well as our post-secondary institutions, both public and private, because we receive federal funding from the Department of Education. So we've had Title IX for a very long time, and that prohibition of sex-based discrimination for a very long time. But in recent years, that understanding, the legal understanding of sex discrimination has expanded to include sexual harassment, sexual assault, domestic and dating violence, stalking, and other forms of exploitative sexual behavior. So we're really privileged to be in a space where we can do this work on college campuses, not just complying with the law, but really transcending that minimum bar to create gender equitable campus communities for all.
That really explains a lot about Title IX. Sarah, was there anything that you wanted to add to that?
Yeah, I think just kind of how we got where we are now with these new federal regulations is also important to understand. previously, the regulations were fairly short. Matt, when was the last time the regulations were revised?
The
Before
actual
2020?
regulations, yeah, it was probably in the 90s, I
Yeah,
think.
that's what I think too. So it's been quite a while since we've gotten new federal regulations around Title IX. The issues from the Department of Education Office of Civil Rights have been sent down to colleges, universities, and other educational institutions through Dear Colleague letters, through guidance, through supportive documents. The reason these regulations are so important and different and getting so much attention is because they have gone through the official rulemaking process. And by adding these to the Federal Register, they now have the force of law behind them, not only guidance from the Department of Education. And so it's even more impactful, I would say.
Understood. That makes a lot of sense. I believe Title IX, the original Title IX, is just a few words, isn't it? And then it's pretty much up to interpretation. Is that right?
So the actual law that went into effect in 1972 was in a body of other amendments to the Education Act, and so there was a lot of different pieces. Title IX, the words were actually modeled after the Civil Rights Act in part, and so yeah, it's 37 words that thou shalt not discriminate on the basis of sex, right? That's about it. And everything else that has happened since then that shaped what Title IX is today has been the result of court cases all the way up to the Supreme Court, federal regulations, rules like Sarah mentioned, and guidance documents that change more or less with the different Department of Education administrations and what their priorities are pertaining to Title IX.
Got it. Thank you so much for explaining that. And kind of shifting gears a little bit, and I think you went into it a little bit, Matt, but can you each tell me a little bit about your respective roles at your colleges?
I think they're probably going to be similar. Mine will be on a smaller scale than Matt's because Rollins has about 3,000 students, where UCF has over 60,000 students. Are we at 70 yet at UCF?
We're very close to 70, I think.
So I think, that as the Title IX coordinator or director of the Office of Title IX at Rollins, responsible for overall college compliance with Title IX, that's the base. Just like Matt was saying, the reason we abide by Title IX is not because the law tells us to do that. I mean, that's a good reason too, but it's the spirit of the law that we want to prevent, stop, and remediate any effects of sexual harassment, sex or gender-based violence, or any related sexual misconduct that might occur on our campuses, as well as prevent any discrimination on the basis of sex. And so at Rollins, that includes sex, pregnancy, or pregnancy-related conditions, gender identity, gender expression, sexual orientation. So it's that wide spectrum of sex and gender that we cover under our Title IX related policies. And UCF is the same. Of that overall compliance piece, we also do a lot of training, education, violence prevention work, meeting with students. We provide supportive measures and options and resources to anyone who has experienced sexual misconduct or sexual-based discrimination or harassment. And then we also manage the formal grievance process for any associated informal remedies that might be available under our different policies around these issues. So it's more than that, but that's kind of the hits, I guess.
Thank you so much. I appreciate that. Anything you want to add, Matt?
Yeah, again, Sarah mentioned our roles are going to be very similar because at the core of our responsibilities is to ensure compliance with Title IX. And so those responsibilities are very similar from institution to institution. We are a larger university, and so our Title IX functions are housed in our Office of Institutional Equity. Our office's charge is to implement our non-discrimination policy throughout the university. So we actually work with a lot more than just Title IX in our office. my specific responsibilities are oversight and management of Title IX and supervision of our Title IX investigators. We have 3 full-time Title IX investigators in our office, in addition to our other staff and personnel. We also work with a campus-wide network of resources under the umbrella of our Let's Be Clear campaign. And that connects us to university police, counseling, student care services, the Student Conduct and Academic Integrity Office, among other campus partners that are helping us all strive toward that gender equity that Sarah was talking about. So we do a lot of different things, but my primary focus is on Title IX.
Awesome. Thank you so much for shedding light on all of that. Really cool stuff. I like that I'm talking to a huge university and also kind of like a smaller one too. I think that gives like a great perspective. So what do you want students and the general public to know about Title IX?
Don't believe everything you hear in the news.
Yeah.
I don't know.
Tell me more.
Well, I think there's so much. The headlines you see, I think, range from sexual assault is rampant on college campuses to colleges are running kangaroo courts and unfairly kicking students out of school. That's the sensational headlines that a lot of us see in the news. And then, as Matt was mentioning, it also becomes very politicized because the Department of Education leadership typically changes administration by administration. And so then guidance and supporting documents might change as well. Part of that backstory of how we are where we are now, the Obama administration, Department of Education, was very much focused on the rights of survivors, complainants, and making sure that colleges were doing everything they needed, and rightly so, to support anyone who had experienced sexual harassment, sexual assault, or sex-based discrimination. Some people thought that swung too far in favor of the complainants or the survivors, and we'll probably use the terminology complainant and respondent. When we're talking about Title IX, it's more neutral language through our grievance processes and our investigation processes. So complainant being the victim or survivor, and the respondent being the person who's accused of the alleged misconduct. And now with the Trump administration, that pendulum has swung over to the respondent's right side. And they are very focused on due process protections, constitutional protections of free speech, and everything that goes along with that. And so really, I think from a practitioner standpoint, we would like to see that somewhere more in the middle, where you can still have a fair, equitable, unbiased grievance and investigation process that protects the right and respects everyone involved, while providing the necessary support for any survivor, complainant, victim who has gone through one of these incidents.
Got it.
I think it's important to remember that at its core, Title IX is a civil rights law. And so the approach that we take with managing really, really intense issues like sexual assault, relationship violence, and stalking, we do so through this civil rights lens. And that lens gets shaped by decades of case law and guidance. And so I think when folks come in, they think Title IX is the going to be the magic remedy for everything that they've experienced. And while our mission is to ensure that students continue to have access to their education and employees to their employment free from discrimination, and we try to manage the effects of sexual assault, relationship violence, and stalking, there are procedures and policies in place. One of the things that we do when somebody comes into our office initially to meet with us is we're very transparent with what our process entails, what their rights are, what their responsibilities are, and the options that are available to them. We don't force anybody to go through a Title IX investigation. And I think that somehow has caught some public attention, that maybe somehow we force victims and complainants to go through this super laborious process, and we don't do that. I think there's also some misnomers about what our role is versus law enforcement's role, which is really to enforce criminal statute, not civil statute. But Title IX works in concert with law enforcement, not in opposition to it. And we can work through our Title IX investigation at the same time or irrespective of whether somebody goes through the law enforcement process.
Wonderful. And actually, that kind of leads to my next question, actually, which is, how is a Title IX investigation different from a criminal investigation in the justice system?
Well, there are a lot of differences. I'll just start with a couple and then Matt jump in too. So I would say that first off, it's an internal process to a college or university that we're talking about. The rules are different. The standard of evidence, the standard of proof is usually different. So in a criminal system, you would have beyond a reasonable doubt that we've all seen on Law and Order and everywhere else, which is a very high standard or burden of proof that the state needs to meet when convicting someone of a crime. In our system, it's a preponderance of the evidence that we're looking at. Now, under these new federal regulations, colleges and universities can choose between preponderance of the evidence, which is just over 50% more likely than not, or clear and convincing, which is a slightly higher standard. What would you say, Matt, about 65, 70%? Yeah.
Something
like that. But we have to use the same standard of evidence for all cases. So in the past, some universities in particular, I think with collective bargaining agreements, might have had a clear and convincing standard for faculty or some unionized employees, and maybe preponderance of the evidence for student cases. Now the new regulations tell us we need to use the same standard of evidence for any case that falls under Title IX related misconduct. So those are some of the main differences with that standard of evidence. There's not typically active participation of an advocate or advisor, an attorney in a lot of our processes. The exception to that now will be for true Title IX investigations, a person's advisor will be able to cross-examine or ask questions in the live hearing of the other party and of witnesses. So there are some similarities, I think, in structure to what we see in the justice system, but it is not akin to the court system at all. And I think that's another misconception that people have. They have a tendency to want to call a hearing a trial, or they want to find someone guilty or innocent or not guilty, where we're usually looking at findings of responsible or not responsible, or in violation or not in violation, because we're looking at policy violations and what rules someone who's a member of our community is supposed to be following. So those are just a couple of things that come to mind. Matt, do you want to add some things? I'm sure.
I think the mission and purpose, there's some overlap and there's some differences, right? Like we're all on the law enforcement side and the Title IX side, we are interested in maintaining the safety and integrity of our communities. So that mission, that charge is very similar. The approach that we take, as Sarah mentioned, to get to that goal is very different. The standards are different. The process is different. In a criminal process, you are taking an accusation of a violent offense through the prosecution cycle, and there's a punitive outcome. In our process, our goal is to ensure that somebody who's been impacted by sex discrimination or sexual violence has ongoing access to their education or their employment. So one of the major differences is we proactively create and implement resources and support for people who have been impacted by sexual violence to connect them to at UCF, our counseling services, our victim services, our student care services, our law enforcement partners, if that makes sense to do so, so that the individuals who've been impacted have those resources and support and all the options available to them. There's some real like basic stuff. I can't subpoena folks. I can't issue warrants. I don't arrest people. Like, that's not what we do. We work through the process to the best of our ability with those limitations. And like Sarah mentioned, we make our decisions based upon the preponderance of the evidence, which is the civil standard that's often applied even in court cases involving civil matters and civil rights issues. And so it's a very comparable standard. And it makes sense because the standard is, more likely than not. So it is an equity standard that gives a fair opportunity to all parties involved to present the evidence and information that they have for their side and have an objective fact finder and decision maker render an outcome based on that standard of evidence. So the other thing that I think is somewhat different is the active role of the parties within. Like, they can be as active as they want to be or as not active as they want to be, right? Where sometimes a criminal prosecution may hinge on the cooperation of a party. Title IX processes don't so much. The burden is on us, the institutional actors, to collect the evidence and to referee the process. And so that's a little bit different as well.
Understood. Yeah, lots of information. Anything you wanted to add, Sarah?
I was just thinking about the adversarial nature of the criminal process too, especially once you get to the court process. Traditionally, our Title IX and other grievance type processes were not adversarial in any way. And we're hopeful that we can set rules of decorum for Title IX hearings that are going to be upcoming with these new rules where live cross-examination is allowed. We're going to have to figure that out anyway, I think, because as Matt's been mentioning the court decisions, courts across the country have been deciding that part of college students, in particular due process rights, involve cross-examination rights at hearings. So I'm not sure that this is going to be going away, even if the administration changes. It might look a little different. So figuring out how we can set the rules of decorum even when we have live questioning or live cross-examination in our internal processes, I think is going to be something important to continue to distinguish us from the criminal system.
Got it. Thank you so much. So going off of that a little bit, I know that some of the services that Title IX offices provide students does not actually involve that hearing or that trial. So can you describe what those other services could include?
So at UCF, we start, our very first outreach is coming from somebody who we designate as our remedial measures specialist. That's the person who meets with the complainant initially, briefly talks about what happened to determine what resources and support that individual may benefit from, what we can do as an institution to support them in continuing to access their experience at the university. And so depending on whether that individual is a student or an employee, we've got a couple of different resources available to them. For students, as I mentioned, we connect them to mental health and physical health services, comprehensive case management services, on and off campus resources as well. We refer them to the Victim Service Center often, right, especially for ongoing needs, or if they're working with the criminal justice system in Orange County, because you all are the experts in that particular area and you can provide those resources. So I like to see our Title IX program as a hub of resources. Anybody that comes to our office who's had an experience of one of these things can access these resources and support, regardless of whether they decide to go forward with an investigation with our office, an investigation with law enforcement, or nothing, right? So that supportive measures piece is 100% of the time. One of the things I actually like about the new federal rules is it really codifies the importance of that remedial and supportive measures piece on the front end of the process and compels institutions to provide 100% of the time those supportive resources to victims, complainants who've experienced sexual violence or relationship violence. And while most of our institutions have been doing that for a very long time, it's nice to see that echoed in the body of federal law.
It's very similar at Rollins. The initial outreach that someone receives will come from me, though I'm a 1.5 person office compared to the resources at UCF, which still are not enough. We felt the crunch when I was there, and I'm sure y'all are still continuing to do that. I think that's the same at every institution across the country, unfortunately. We could always use more support and options, but so I would, once I receive a report or a disclosure or someone comes to my office, it's the same thing. Reaching out, providing options, resources, information on accommodations. We can do things like changing classes, changing residence hall rooms, job reassignment, no contact orders if that is something that someone needs for a safety measure, and different things like that. I think one thing that our students always ask is, well, do I have to engage with you? So you send me an email, you reach out, do I have to do anything? And the answer is no. You don't have to do anything you don't want to do through this process. The reason that we want to reach out is to provide consistent information about the options, resources, and support that are available, and make sure that people know that those things are available to them, and that they also have access to confidential resources if they don't want to speak to somebody who might have to make a report to another office on campus. We don't have in-house victim advocates, so we do refer to the Victim Service Center and Harbor House and our other community partners as appropriate, depending on the situation. We rely on y'all to provide that ongoing victim advocacy services to students, faculty, and staff at Rollins. We do have a wellness center, counseling center as well. And our Dean of Religious and Spiritual Life is also a confidential resource on campus. She's just an amazing person, even if you're not religious or spiritual. She's a wonderful person to connect with and talk to. So just, echoing what Matt said, student and family care, a wide network and collaboration of resources on campus where people can get the support that they need, as well as connecting them to those resources in the community where we can't provide the ongoing services that they need.
Got it. And you both kind of mentioned this too, that, Title IX isn't just for students. So how do your offices work to keep faculty and staff safe at your campuses?
I think that's a really important point, Emilie, and I think we get caught up in the public discussion about Title IX focused solely on students, but the law reads that no person, period, should be subjected to sex discrimination. So in a university like ours, that covers our students, our faculty, including our adjunct faculty, our full and part-time staff, other employees, guests who come and visit our campus, contractors in relationship with our university. So it's a very broad net of folks who are covered under that. Employees have the added civil rights protection of Title VII of the Civil Rights Act as well, which prohibits discrimination on the basis of sex in employment. And so they have that added layer of protection. At UCF, we kind of wrap all of those civil rights laws together into our non-discrimination policy, and it covers all the bases that Sarah already mentioned, even a few that are not enshrined in Florida state statute, like gender identity, gender expression, and sexual orientation. Prohibition of discrimination on those identity bases. So we work with faculty and staff. We provide similar, but different, because their role with the university is different. We provide similar resources and support. We can work with them through an investigation should they choose to go that route. And we try to do really good awareness and prevention programming with our employees like we do with students. And so we make sure that our services are accessible to all.
I would say too, along with supporting any faculty or staff member and students, of course, who is experiencing one of these types of incidents or involved in the process in some way, we also call on our faculty and staff to help us in reaching survivors and complainants, because they're often the ones who receive the disclosures initially. So when you think about a trusted faculty member. You think about our resident assistants and our hall directors in housing, and just different student affairs support people. They often are the people that students in particular go to. So we try to provide training that teaches them how to respond to a disclosure in a safe but sustained way. Kind of the basics of like diet crisis intervention or something, I guess I would say. Like, is the person safe? If not, let's get them to a safe place. If they are safe, tell them you're sorry, express empathy and concern, and then connect them to a resource on campus that can provide more in-depth services for what they're going through. So we call those faculty and staff members responsible employees or required reporters. I think it's different than a mandated reporter, which we think about in terms of like child abuse or elder abuse or otherwise, people who can't make decisions for themselves in that sort of way, because it doesn't have that force of law. And we're typically talking about people who are adults with agency who are making these disclosures. So it can be a hard sell sometimes to get people on board with their responsible employee duties, because they take the trust and confidentiality of the people who are telling them their stories very seriously, as we would want them to. But like we were saying before, the reason we want everyone to get to our offices is to make sure that they have that complete list of options, resources, adjudication or responsibility measures that are available to them, and all the supportive measures that sometimes can only come through our offices and for certain accommodations. So I would say we try to support faculty and staff in that way by educating them to be able to support their students and colleagues too, in case a disclosure occurs.
Got it. And actually, I wanted to bring up, what would you say to a student or faculty member who is hesitant to go to the Title IX office for support?
I think we recognize how challenging these circumstances are for an individual, right? All of our staff members in our office receive regular training on trauma-informed practice, really with the goal of meeting complainants where they are in their process. The thing that I would reinforce to a student or an employee who is really hesitant to visit us is that visiting us doesn't commit you to anything. It's an opportunity for you to explore the options that are available for you. Sarah mentioned we're all adults, more or less, and we have agency and free will. And our goal is to really make sure that we're not impeding that free will, right? That we're giving choices and giving options and allowing somebody to choose for themselves the course of action that makes the most sense for them. So you can always come in the door and you still have that choice.
Yeah, and I mean, that's exactly what I would say too, that while we're not confidential, we are private. We are not going to share anyone's information or anything like that. You always have a choice of whether or not to come in at all. And if you don't want to, you don't have to, but it never hurts to have a conversation and learn what's available, because there might be support there that you never knew existed. There might be an option for, let's say, an informal resolution if you didn't want to go through an investigation that you never even knew was available, and you might be able to hold someone accountable or have them learn from how they harmed you. But if you don't walk through the door, you might not be aware that those kind of options are available. So I think we always think of ourselves as very, open, empathetic, kind, compassionate, which I think we are, and all of our staff members are too. I can vouch for my office and Matt's office for sure. But I think until sometimes people have a personal interaction with us or with one of our staff members, or they have that caring faculty or staff member to bring them along who knows us, it can be a barrier and can be difficult. So I would just say reach out and have the conversation if you're even just the least bit curious about what might be available to you.
I think the other thing I would add to that, Sarah, is that at least in UCF's policy, and I think it's this way at Rollins too, folks come in, are sometimes hesitant to come in because they're like, oh, this happened 6 months ago or 2 years ago or 10 years ago. What possibly could your office do for me? We don't have a quote unquote statute of limitations within our policy regarding sexual or relationship violence. And so somebody can come in and explore their options regardless of where something occurred or when it occurred. It doesn't have to have been on campus. It could be, we all went to Cancun for spring break and something bad happened to me there and I need help. We can work with those students and those employees to make sure that they're getting the resources that they need. And in many circumstances, the option to investigate still exists.
Got it. Really good information to have. I really appreciate that. Kind of switching gears here, and we delved a little bit into it, but I think we should delve really into it now. Like we mentioned earlier, Betsy DeVos released I think it was around 2,000-page document detailing the many changes to Title IX that will go into effect again later in August 14th. So what are the main impacts that you have identified or expect for this next semester? And are there positive and negative impacts that you wanted to share?
2,033 pages, Emilie. Wow. And I've read every single one of them, certain pages multiple times. So just real quick to kind of zoom out to the bigger picture on these. The 2,033-page document came after a 1.5-year-long rulemaking process. There was a proposal, there was public comment, there were more than 120,000 public comments that were received by the Department of Education before they finalized the rules in May and issued this 2,033-page, behemoth of a rule. But there's only about 24 to 26 pages of actual regulation, actual law in that document. The majority of it is discussion, what we call the preamble, which is the context where the Department of Education gets to state their case for why the new regulations go into effect the way they do. And so there was a lot that went into this. We had anticipated for a better part of a 1.5 years that at some point in time we were going to get this document. And ultimately, it's much larger than we wanted it to be or thought it would be, but it is nonetheless what it is. We've been carefully reviewing the rules since the draft version was published in May to try to figure out how to implement them by the August 14th deadline. We're looking at different administrative solutions like revising our policies and procedures to comply with the federal rules. Like Sarah mentioned, unlike previous guidance documents that were issued by the Department of Education from 2011 to present, these are the law. We have to comply with them. While there have been lawsuits and injunctions filed against the Department of Education trying to stop the implementation of the rules, we're still working on the assumption that they're going into effect on August 14th and anticipating to comply with those.
And we're stressed and freaking out.
And we're stressed and freaking out a little bit. But I think all of us, right? Like every Title IX coordinator that I've talked to in the entire country is like, great, okay, how are we going to make this happen? And the Department of Education's response is, we gave you ample time. Again, this rulemaking process has been over 1.5 years in the making. They actually issued the draft regulation in May, giving us more time than was federally required to implement. Not a ton more time, but more time than was federally mandated. They could have said as soon as 60 days from the drop of the reg, but it had to be in full compliance. They didn't.
How long the document is, it doesn't matter how many regulations they put on. It just has to be 60 days.
It depends. Some of them are 30 days. Like if there's all of these rules regarding
Okay.
process. So they can drop a set of federal regs and say you have to comply in 30 days. But with this one, because there were substantive changes that potentially would have a financial impact on the universities, they were supposed to give us 60 days, and I think they gave us like 100.
Yeah, about 100, I think.
So this is very kind.
Generous.
Generous time. In the middle of a pandemic too.
Right. It does seem like the perfect storm a little bit. Going off of that, are there any positive and negative changes that you'd like to highlight? And Sarah, feel free to jump in at any time, of course.
I mean, I think we're trying to look on the bright side to the extent that we can, because there are certain parts of the final rule that are difficult in terms of implementation and difficult in terms of practices that colleges and universities have been using for a long time to protect our constituents in terms of faculty, staff, and students. The most concerning piece for me, I have to say, is the live cross-examination by the advisor of the party's choice, because that can be anyone. So it can be an attorney who's very well versed in the rules of criminal procedure. It can be a parent. It could be a friend. So, I mean, it could be someone's fraternity brother or sorority sister who is then representing them and asking live questions or cross-examining the other party, which can be pretty difficult. They have added the provision that the college needs to provide an advisor for the hearing if the parties don't have one, which I think is wonderful, especially in terms of equity, as we think about people who, at least I've seen, who have participated in these processes. A lot of times, the respondent in particular hires an attorney and has the means to be able to do that. Or if they don't, their families are trying to take out loans and mortgage their house to pay for this legal defense that you don't necessarily need in a college or university process. But given the weight of an accusation of sexual misconduct, they feel that they do need that representation. So it's long been a concern for me, equity-wise, about the ability of one party or the other to hire an attorney, or someone who might benefit from an attorney not having the means to hire an attorney. So I think that's actually a good thing in the rules. But the live cross-examination piece concerns me. It's not even so much the live hearing, which is different for Rollins because we don't have a live hearing in our current process. So we will be making some changes to institute that live hearing practice.
Wow.
But it's not even so much the live hearing. Of course, we can have concerns for re-victimization or re-traumatization anytime you have to face the other party in a situation or be asked questions or tell your story to someone you don't know. But what schools have been doing in live hearings to limit that is allowing people to not have to see each other. They'd have the option to not participate if they didn't want to participate. They could be in separate rooms, or they could listen but not see video. Now the new rules have required that you can see and hear the other party while they're being questioned. And I think that has some potentially detrimental effects for our complainants and respondents. I think it'll be a very difficult process to go through in terms of that. But I do like that the college needs to provide an advisor if a party doesn't have one. Another thing that I think is interesting, and it took me a while to come around to this, is the informal resolution piece. So the new regulations tell us that in any case of sexual misconduct, including sexual assault, intimate partner violence, we can use informal resolutions. Now, I think we all know that research and practice has long supported that in cases of extreme power differentials, if we're talking about violent or penetrative sexual assault, dating or domestic violence with physical violence, especially strangulation, and some of those big risk factors and red flags we see for lethality or ongoing severe stalking, that we would not encourage people to engage in an informal resolution in that process because of the power differential and the power and control issues in those situations. I still agree with that. However, I am looking at this as a real place for us to come from a survivor-led justice focus. And so this could potentially give the complainant or their survivor a lot of agency in determining how we move forward with certain cases. We hear so many people who say, I don't want to get the person in trouble. I don't want them to be kicked out of school. I just want them to know that what they did is wrong and it hurt me, and I never want them to do that to anybody else again. This extension of informal resolution processes might give us more opportunity to get back to our educational mission as institutions of higher education. We don't have a true restorative justice process at Rollins, but I'm thinking this might open the door for us to establish something, which would be great all around on our campus, I think. So there'll still be some prohibitions on when informal resolution is allowed or not allowed, and especially where we use things like mediation, where the parties would come together to come to some sort of agreement. But you could still have an informal resolution where you never have to have contact with the other party, where they just need to have an educational conference with someone else, and there could still potentially be educational requirements or disciplinary sanctions that come along with an informal process. Might also give respondents the opportunity to take responsibility and be reflective in certain situations and figure out how they can learn and do better and not harm anyone again. So those are some silver linings that I'm trying to remind myself of and pull out of there.
Yeah, anything you want to add, Matt?
I agree with Sarah's summary of some of the challenges and opportunities there. I think that one of the things that I've heard from colleagues is that there's seeming contradictions within the document, right? Anytime you have something that's over 2,000 pages long, there's bound to be contradictory guidance. And so we're looking at the text of the actual regulation, but then there's aspects maybe of the preamble that are not matching that. And the preamble is meant to shape our understanding of the regulation. And so I think a lot of us are trying to figure out, what is this going to look like in actual practice after August 14th? And there's a lot that we just don't know. So we're making a good faith effort to do the best we can to comply and move forward. And we will pivot and we will make adjustments in real time. Some of the positives, I guess, or silver lining moments for me personally, this is the first time that in the actual text of regulation, we see that domestic violence, dating violence, stalking, and sexual assault are intricately now bound up with Title IX. We've understood that to be true. Like, of course, sexual assault is an egregious form of sexual harassment. Like, we know that to be true. But the law didn't necessarily reflect that specifically. And so that's kind of interesting. Granted, we've had that from like the Clery Campus Safety Act perspective for a while, but not from the Title IX perspective. And while we've been investigating and adjudicating sexual misconduct, relationship violence, and stalking for years, this gives us a very clear connection to Title IX. We also, for better or for worse, now have super concrete rules guiding the process. And we've not had that in the past. We've had guidance, sometimes contradictory guidance, and a lot that's been left unsaid about what a Title IX process is supposed to look like. And now it's right there in black and white, exactly what universities are expected to do. The last thing that I would mention is that I am concerned that all of the public kerfluffle over the regulations and some of the misinformation that's going out about Title IX in its current moment is going to chill reporting and discourage complainants, survivors, victims from coming forward about their experiences because it doesn't meet some narrow prescriptive definition of what sexual harassment is supposed to be. While Title IX tells us what we have to do, it sets the floor, not the ceiling. we can always transcend that minimum bar and do. At UCF, we're committed to continuing to address sexual and relationship violence that occurs anywhere, regardless of whether it's on campus or off campus, or who the parties involved might be, to the extent that we're able, to make sure that we're addressing the behavior and remedying its effects.
Going off of that, we did talk a little bit about how we believe it'll be impacting survivors. And you said that there are still things that Title IX can do, and you're afraid that people might not come forward now, but there's still ways that Title IX offices can still support survivors. So how can Rollins and UCF's Title IX offices go about and try and remain survivor focused? And how much discretion do these offices at higher education institutions have over the adaptation and implementation of the recent Title IX changes?
To answer the last part first, again, these rules are the law. So there isn't a lot of flexibility because it's the law and we have to comply with it, whether we like it or we don't. There's certain aspects of the new regulations that are minimum must do sort of things. And there's other aspects that we get a little bit of discretion and flexibility around deciding how we want to do certain pieces of the process. And so as we're writing our new regulation at UCF to meet those new rules, we're exploring options to continue to make the process as seamless as possible for individuals, accessible, and fundamentally fair as they should be. So we're going to continue to provide a broad range of supportive measures to impacted individuals. We're going to work closely with our victim services partners on campus so they can give us real-time feedback about how the process is landing for their clients, and working with our off-campus partners as well to ensure that complainants continue to get those resources and support. That said, we also provide support and resources to respondents or accused individuals. That's been kind of a mandate for a long time. And I think sometimes that can land like it's not a survivor-centric process. But remember, the charge of Title IX is to ensure that all people have access to their education, as long as it makes sense, right, for them to be in our community. So we provide those supportive measures to make sure that everyone can navigate the process seamlessly. And then that opens us up to a fair process that comes to a reasonable outcome and conclusion for all parties involved.
Thank you so much, Matt. Sarah, is there anything that you'd like to add to that?
I think, as Matt said, we'll continue to do the good work that we've been doing for many years to support both complainants and respondents through the grievance process. We will continue to offer confidential and non-confidential resources, supportive measures, accommodations, really whatever someone who's been impacted by sexual violence might need to attempt to feel whole again and to not lose their access to education, as Matt said. We'll continue to do violence prevention education, active bystander intervention education. The bottom line is that no one thinks sexual violence is a good thing, right? So if we can all get on that same page, which the vast majority of people are, and we teach people, our students in particular, thinking about our young people on our campuses, the nuances of consent. What are some of the issues that people experience when they don't communicate clearly, when they don't ask? How can you navigate some of these relationship issues and recognize red flags and engage in healthy relationships instead of abusive ones? I think what we're trying to do is really look at that pro-social prevention education approach as one component of what we're trying to do to show survivors that Rollins cares and that we will support them. It can be difficult from the Office of Title IX perspective as well. We talk a lot about institutional betrayal at Rollins and how people might feel when they go through the process, especially when they're met by someone who is caring, compassionate, provides them all the options, resources, and support that are available. And then maybe the resolution process that's available to them doesn't fit with what they want to do, or they don't want to go through an investigation, but that really is the option that's available in terms of holding someone accountable, is to go through that formal process, and that's not right for them. So sometimes I think we talked about this earlier, right? The expectations of Title IX being able to do everything for everyone is not always the case within the law and the rules that we have to follow. But we do our best to be transparent and demystify that process and be clear on what the Office of Title IX can and can't do, and then where you can get additional support if you're looking for something else. But always making sure that we're treating people with kindness, compassion, respect, and in an equitable way, and recognizing that we need to provide the option and support that people need for them to feel comfortable to continue their education or their access to our programs.
Absolutely. And you both mentioned that, Title IX is there for everyone, for every kind of student, faculty member, and even guests that you mentioned earlier, Matt. So I did want to go into specifically, what does Rollins College and UCF have plans to provide further support to their students and faculty members and staff with disabilities, those with lower income, those who identify in racial, ethnic, minority groups, and other underrepresented, vulnerable student and faculty and staff populations in response to the recent Title IX changes?
It's an interesting thing, because Title IX doesn't, as a law, right? It doesn't really address intersectionality. No federal civil rights law does. Like, that's just not how they work. And so it's incumbent on us to ensure that we are continuing to learn and grow as practitioners, to meet students where they are and understand the nuanced ways in which sexual and relationship violence impacts people across lines of difference. We strive to make our processes as equitable and accessible as possible. We do seek out feedback on that, working with student organizations, student government, try to get some feedback around, does this process make sense? Is it accessible for all? I think one of the things, particularly with the socioeconomic disparities in terms of resources, is what Sarah mentioned earlier. We have to appoint advisors in the process now, which is a great resource. And probably we should have been doing that from the beginning, right? Like, and we make folks available, and we let them know that they can, choose their own advisor or support person. But to really put that onus on the institution to do that, I think creates an opportunity for us to break down some of those barriers to access and equity. Our staff at UCF are continuously trained on working with survivors of violence around those intersections of identity. So we regularly attend online and in real life sort of trainings and stuff when there isn't COVID floating around. We hope to do in-person training again. And we outreach to our specific communities on campus to have those conversations. We recognize that Title IX can feel like a very bureaucratic process, and that doesn't feel accessible to all communities, right? And so we want to make sure that we're getting that feedback so that everybody feels comfortable and confident in accessing our services.
I concur with everything Matt said, and I think going back to the prevention education piece with some of these different populations on campus is also really important, to have specific conversations. Like if you take people with disabilities, for example, we know that they may be victimized at a higher rate than other people without disabilities. Having those conversations with our Office of Accessibility Services, with our student groups, to make sure that they're aware, to raise awareness, but also talk about prevention and then what options and resources are available. The fact that someone can bring an advisor with them to any meetings they have with us, whether whether it's just an introductory intake meeting, an investigator meeting during the hearing, also gives people the option to bring someone who they might be more comfortable with. We're exploring at Rollins how we can either expand our confidential resource pool or create almost a Title IX liaison kind of system with different folks around campus who work with students in some of these different populations. So thinking particularly of our students with disabilities, our students who are people of color or Black, especially in the wake of all the racism that we're seeing around the country and the anti-racism work that we're trying to actively engage in, our LGBT students. They're often not comfortable sharing, as you know, they're often not comfortable sharing when they might have been victimized, especially with someone they don't know. So trying to increase opportunities where they feel comfortable disclosing if something has happened and they can get the right information and resources from someone they trust is a high priority for us right now as we're reviewing all of our policies and procedures.
Absolutely. And you've touched on something that I wanted to kind of delve in specifically, which is the LGBTQ plus community. So how can your Title IX offices support students and faculty in the LGBTQ plus community, specifically trans folks right now?
I think I want to start with dispelling some myths, I guess. So, or clearing up some rumor and speculation. So, under the Obama administration, we had received guidance that transgender individuals were protected by Title IX from discrimination, right? And we've always held that all individuals, regardless of their sexual orientation or gender identity, should be able to attend school without fear of sexual assault, relationship violence, and stalking. So we actively provide support and resources to queer and trans victims of violence, as well as investigate those cases. And we've received additional training in our office, to navigate those nuances. But when the Trump administration kind of changed the Department of Education's stance in 2017 and said no longer does Title IX protect transgender individuals from discrimination, I think that made it feel like trans and queer students didn't have any options. Even though that's not strictly what it said, that was the impact. And still to this day, there's no court case that's decided that Title IX applies definitively to anti-transgender discrimination. And that leaves this big, hole, right, in both federal and state law, because in Florida, we don't have protections on the basis of sexual orientation and gender identity as well. But at UCF, a number of years ago, we added gender identity, gender expression, and sexual orientation to our non-discrimination policy. Our Title IX staff actively works to investigate and adjudicate those cases. So at least at UCF, we've got that commitment enshrined in our policy, and we take that commitment extremely seriously. So if a trans or queer individual has experienced discrimination because of that identity at UCF, we want to hear about it so that we can remedy that. And certainly, if a trans or queer individual has experienced sexual or relationship violence, we want to know that too, so we can provide resources and support and investigate if we have the ability to do so. So we work with our LGBTQ plus student services office on campus and our social justice and advocacy office to ensure that we're getting that message out to our students and employees to dispel those really awful rumors and myths that this process is no longer theirs.
Thank you so much for shedding light on that. I think that's really important information to put out there. Sarah, was there anything that you wanted to add, or did Matt kind of cover it all?
Matt definitely covered it. I also want to point out the importance, I think, of inclusive examples in any training or educational materials that we put out, making sure that we're showing a wide variety of different relationships, different people with different identities. And as Matt mentioned, talking about the intersectionalities. that come along with all these different identities. I think that's important. If you can see yourself or see your friends or your family members in the examples, it makes it feel more personal and like maybe it does apply to you. And I think the more we can do, whether it's passive outreach campaigns of, sending out reminders about different protections for different communities, or maybe we did this at UCF several years ago. We had a panel specifically for our LGBTQ plus students who were concerned about how Title IX could protect them or did not protect them. And a lot of grassroots efforts happening at the institutional level to make sure that all members of our community have these protections on the basis of sex, gender expression, gender identity, sexual orientation. That whole inclusive spectrum of gender and sex is something that we're committed to at Rollins as well.
Definitely. And you brought this up way earlier in our discussion, but one of the things that I actually didn't know about Title IX was that it also protects pregnant students and staff. So can you tell me a little bit about what that entails?
Yeah, it's interesting, right? Like we sometimes forget that if a pregnant individual is being discriminated against because they're pregnant, that is implicitly sex discrimination. And so, of course, Title IX applies. We also, for employees, we lean into Title VII and the Pregnancy Discrimination Act as well. So in our non-discrimination policy at UCF, we include pregnancy and parental status as protected classes. If an individual is pregnant or experiencing pregnancy-related conditions or complications, they can come to our office to explore some options. And we work with that individual through an interactive process to make sure that we are providing reasonable accommodations for them to continue to access their education or employment. And that could be, again, things like classroom modifications, remote learning, those types of things. Of course, there's always going to be, those outliers where we can't accommodate a particular course or something because the nature of the course just can't be accommodated. So we work with the individual to make sure that they, to the best of our ability, stay on track to complete their degree, work around those requirements if we can, or postpone their enrollment in those courses if it makes the most sense to do that. So we do ask at UCF any employee or student who is pregnant who may benefit from additional resources, support, or accommodations to contact our office.
Sarah, you want to add anything?
No, I think it's pretty much the same. I work closely with our Office of Accessibility Services on our pregnancy cases. We actually don't have that many student cases at Rollins. But, when we do, a lot of times if they run into trouble when they're asking for accommodations, it's simply because a faculty or staff member doesn't understand what they're going through, or they don't want to share private medical information and things like that. So having a conversation about accommodations and support that are appropriate for someone's pregnancy or parenting status come along with that as well. And a general extension, I think, that is a good part of just gender equity progress is we're seeing things like lactation rooms on campus and preferred parking for pregnant people in their third trimester. It might be harder to get around. So some small steps like that to be able to support our populations who are pregnant can go a long way.
Awesome. Kind of shifting gears here a little bit. Do your campuses happen to have good faith policies for students who were assaulted or whatnot and may have been maybe underage drinking or using illegal drugs that would otherwise violate student conduct?
We do. We have, we call it our amnesty policy, which is going to be similar to what UCF has as well. So we want people to report and to seek services and assistance if they have been impacted by sexual violence or other types of sexual misconduct. And the idea that someone would be fearful to come forward or report an assault because they might get in trouble for drinking is not something that we want to happen on campus. It's far more important for them to get the initial support, health care, mental health care, and information that they need to try to start recovering from that traumatic event than to worry about a student conduct violation for underage drinking or something like that. If it's depending on the situation, we may still include educational requirements for someone who's involved in a Title IX case where there seem to be issues with drugs or alcohol that are more than just a one-off kind of situation. If it seems to be an ongoing problem where somebody might need some help in terms of recovery or looking at their drinking or drug use behaviors, we do some recommendations around that for the educational and recovery aspect, but it's not anything punitive. They would not have a sexual or a student conduct case or any disciplinary action because of that.
I think I echo everything that Sarah just said. I would add that we're really aware of the stigma attached for complainants who were assaulted under the influence of drugs and alcohol. And we recognize that may feel like it creates an added barrier to us investigating a case or something of that nature. But regardless of the circumstances, somebody who has been victimized is entitled to come to our office and have that conversation and seek resources and support and move through the investigative process. Just because somebody is using alcohol or illegal drugs does not imply consent to sexual activity.
Absolutely. Really, really important information to have out there. Thank you so much. Kind of a completely different gears switching here too is, with more students enrolling in online or virtual classes, what kind of violence and harassment might we see more of, and what should students and faculty know about how your offices can still support them even in a remote setting?
Oh gosh.
We're still here. We're still here. We are open. We are open amidst COVID. We are open in the summer. We are open and here if anyone experiences anything that could be considered sex or gender-based misconduct, violence, harassment, discrimination, to talk out situations, to talk about options, and things like that. We have earlier this summer or probably in the spring when we first went remote, we had some Zoom bombing incidents with explicit content that were very harmful to the students, faculty and staff who were involved in the class. It was not someone in our community. So it involved reporting to police, reporting to IT, reporting to Zoom. It was just a really terrible situation because the person who was running the class did everything they thought they needed to do for privacy, and it still didn't work. Someone was able to hack into the meeting. So we are seeing some of that, or people popping in who don't belong in a particular class to make rude comments, or comments about a faculty member or something like that teaching a class. And we already see a lot of this on college campuses, but I think we're going to see more in terms of unhealthy relationship behaviors, relationship abuse, stalking, especially cyber-assisted stalking and relationship abuse, all the text messages, all the messages on all the social platforms. I don't know, Matt, how many pages of documentation do we get in investigations that are text messages, private messages, DMs from social media, screenshots of Snapchat, all these sorts of things are already what we're seeing in these cases, and especially what students are going through. And I think it's just going to become even bigger than what it is now. And then I also think we'll start to see more concerns with verbal or written harassment because you have that protection of being online. You tend to dissociate a person with being a person and might let your guard down and say things that maybe you wouldn't say to their face, but you're willing to say that in an online forum, which is really sad, especially thinking about our educational communities. But I think we'll see some more of that in class and in just chat rooms and different groups that we're trying to establish to keep the community going. I also think, though, that we're going to see more activism around sexual violence and violence prevention, very much like we've seen in the Black Lives Matter movement and this anti-racist movement that's coming to all of our campuses. We've already seen some of that with the #MeToo movement and things like that, but students are becoming more and more vocal about what they expect from their colleges and universities and calling out what they see as injustices and using social media platforms to do that. So I think we're going to be held accountable in different ways now, too, that we're doing a lot more of our work virtually.
I think that, yeah, cyber harassment and bullying continues to be, a very clear and present concern for all of us. And so we've tried to do educational programming and information sharing about steps that folks can take to protect their online identity. Trying to keep some separation between the technologies and platforms they're using for school and the ones that they're using for personal, so there aren't accidentally, they don't get conflated or what have you. We can investigate stalking or cyber harassment regardless of where it occurs, and so students and employees should continue to report those concerns to us and let us know. We may, depending, it's really hard sometimes to figure out who this random Twitter handle person is that's harassing you, but minimally we can support the individual through action steps that they can take to restore their safety. Working with victim services on our campus or victim service center, and the broad range of networks available to you all, as well as what we have at UCF to ensure that they can continue to be in cyberspace in a safe and affirming manner.
Definitely, especially during this time. I think that's really, really important to highlight. As a final question here, one of the arguments or questions I see a lot on college campuses is this idea that so many people are filing false reports, or what will happen if someone falsely accuses me of rape, that kind of thing. So can you talk a little bit about how you handle false reports and how often they occur?
Certainly that's in the discourse of the new regulations. It's in at least a couple of footnotes, and it's in the preamble, and there's an actual regulation requirement that we have to notify parties on the front end now that willfully filing a false report is a violation of Title IX, or the rules around Title IX. I don't really have specifics at UCF about how frequently somebody may or may not file a false report, but I just want to reiterate in no uncertain terms for your listeners that there is a big difference between somebody filing a report and us not getting to a finding of a violation and actually filing a false report willfully and maliciously, right? Just because we can't, we've done all our investigative steps and we can't prove that something occurred based on that preponderance standard, we can't substantiate it, doesn't mean it didn't happen, just means we can't substantiate it. That's not the same thing as filing a false report. And I think a lot of the respondent right groups in particular have kind of focused in on that's a false report, and it's not. In the very rare circumstance that there's information that we uncover during the investigation that determines that someone has filed a malicious and willful false report, we'll work with our student conduct office to referee that issue. But that is by no stretch of the imagination the norm.
Yeah, I mean, what are the national numbers? Less than 3% of sexual assault reports are actually found to be false. I say on college campuses, it's even less than that, at least in my experience and all the cases that I've seen as an investigator, a victim advocate, and a Title IX coordinator over the course of my career in a higher education institution. Most of the time, just as Matt said, it's not something that maybe could be substantiated by the evidence. Maybe it's not something that we can reach a preponderance of the evidence to have a finding of responsibility, but that doesn't mean that the complainant didn't experience something. It doesn't negate the harm that they felt or that was caused to them. And it's not a false report in those situations. I would say for anyone who's concerned that a false report might be filed against them, that's the reason we have the grievance process and the investigation process, and why all these rules are in place, because we recognize that the stakes are high when someone's accused of sexual assault, dating or domestic violence, stalking, sexual harassment, and we want to give them a fair process to uncover all that information and then to reach a conclusion of not responsible if that is what the evidence shows. So, I think that's one thing that I tend to tell people if they're concerned about that piece in terms of false reporting. But just want to reiterate that it is very rare in my experience that we receive malicious, willful, knowing false information or false reports.
Yeah, thank you so much for highlighting that, both of you. It's really important to do that. In my trainings as an education coordinator, I always talk about false reports of sexual assault as well. And yes, the numbers are very, very low. You're just as likely to be falsely accused of murder as you are of sexual violence, but there's a lot of stigma around it, I think. So it's really important to break that down. With that, that's the only questions I have left. So Matt, Sarah, is there anything else that you want to bring up before we sign off here?
I just hope that folks understand that our role as Title IX professionals is to be of service to our communities. And so if anybody is interested in connecting with our Title IX folks at UCF, all they have to do is call, email, or stop on by. All the information about UCF's Title IX program, the resources and support that we offer to everyone, and information about our process and filing a report can be found on our website, letsbeclear.ucf.edu, because we do want everyone to be clear that UCF is a community that does not tolerate sexual and relationship violence, stalking, or sex-based discrimination.
Yeah, I echo Matt's sentiments. If anyone has any questions or is confused or wants to discuss the new regulations or one of our policies, we welcome those conversations. We would far rather somebody email us or call us on the phone or set up an appointment and have a conversation than them go through life or talking to other people with a sense of confusion or incorrect information about what our office's missions are and what we're able to do for students, faculty, staff. The same for Rollins. All of our information in terms of contacting us and reporting is available on our website, rollins.edu/Title IX. That's Title IX with the Roman numeral. And I would also encourage folks to reach out to their advocate at VSC if they have questions. And then we're always happy to have conversations with people and their advisors, or just with the advisor. If you have questions about the process and they don't want to ask us, ask someone else to ask us. Use your active bystander intervention training and delegate the responsibility to someone else to help you out to get the information you need. I think that's super important and what we want and encourage on our campuses.
Awesome. Well, thank you both so much. I think we could probably be talking about Title IX for more and more hours. So I really appreciate that y'all be available for people who have more questions, because I think that this conversation could definitely keep going. But I think that's a wonderful place to sign off. So thank you for listening to the Victim Service Center podcast. The VSC is a nonprofit organization that provides free confidential counseling services for victims of any kind of trauma in Central Florida. To learn more about our services, please visit victimservicecenter.org. And to everyone listening, healing is not linear and you're not alone. And thank you so much, Sarah and Matt, for joining me today.
Thank you, Emilie.
Thanks, Emilie.